SJC-12089, Commonwealth v. Aaron Hernandez.
Ms. Anderson, good morning. Give us one moment and we can get you started. And you may proceed.
Good morning, Your Honors. May it please the Court, Teresa Anderson on behalf of the Commonwealth, and with me this morning, Assistant District Attorneys Patrick Hagan and Janice Smith. We're here today to address and resolve some of the issues that were left unresolved from the In Re grand jury investigation case. We are now before this Court with a more complete record, and a couple of additional factual findings are worth pointing out from the outset. First, Judge Locke found probable cause to believe that the cell phone contains evidence related to the witness intimidation crime. Second, Judge Locke found that 14 days is a reasonable period of time for a law firm, here Attorneys Rankin and Sultan, to provide legal advice and to possess that cell phone. Here we offer two avenues for the Court to provide the evidence to the Commonwealth. In these circumstances that we are now in, we return to the premise that evidence that's unprotected by a privilege and it's held by an attorney, although no longer necessary to the provision of legal advice, must be disclosed. It's not insulated from disclosure, and it does not receive greater protection in the hands of an attorney than it would receive in the hands of the client, and here the defendant.
Let me ask you, under Fisher, if you were to go the subpoena route, does Fisher require that the non-privileged cell phone and the non-privileged, which are not protected themselves by the attorney-client privilege, but the only reason that they're protected is because they were given over by the client to the attorney for the purpose of getting legal advice?
Correct.
If the provision of legal advice is no longer necessary in connection with that, does the Fisher privilege end?
It does. It no longer protects the item. The Fisher privilege is the attorney-client privilege. It is the Fifth Amendment protection that the client has, the defendant has, from a subpoena from the government. A search warrant would be required to get the item of evidence from the defendant. From
Mr. Hernandez?
Yes, in this situation,
but
yes.
Not from the lawyer. If the cell phone was given over and the legal advice was rendered, and there's no purpose then in having the cell phone. So the attorney-client privilege then, as to the cell phone, ends?
Correct.
Don't you still have the problem, though, of the lawyer, maybe you don't, but of the lawyer giving over something that would be like the client giving it over, and so that the testimonial act of that is still a problem? No?
I don't believe you do, because that is protected by the attorney-client privilege. And again, where the attorney is holding the documents longer than necessary, there is no privilege.
It's essentially, it would be like if you went to the gas station attendant?
Correct. Holding it as any other citizen, as any other person, as any other storage facility. I think that would be the one way to access the device.
During round one on this matter, we looked for cases, in terms of Fisher and the privilege issues somehow ending or dissipating with the no longer the need for the item in order to give legal advice. And I couldn't find anything. Could you find anything?
I could not. And so in my brief...
Since Fisher, I mean, nothing, huh?
No, and hundreds of cases that cite Fisher. And in here, so in my brief, I rely on Fisher, and I rely on this court's decision in Re grand jury, both the majority and the concurring opinions, and the proposition that the phone here cannot receive greater protection in the hands of the attorney than it would receive in the hands of the client.
But I guess the point, well, where I was trying to go was, if the client still had this phone, and that you would still have the Fifth Amendment problem of handing it over.
The production.
Production.
Yes.
So why isn't that still a problem for the attorney?
Because the attorney only stands in the shoes of the defendant insofar as there is a proper purpose for the attorney to have that device, as long as the attorney-client privilege protects the attorney from production. The attorney does not step into the Fifth Amendment right of the client. The attorney has a special protection by the privilege, and that dissipates once it's no longer protected by the privilege.
So you wouldn't try to establish that this was Hernandez's cell phone by the fact that the attorneys produced it in response to either a subpoena or a search warrant requiring its production?
Never, correct.
How does that get guaranteed, apart from your assertion that you would never try to do that?
I think it's a simple motion in limine, and again, it would be to establish possession and ownership of the device through other means.
So you'd be essentially carving out some kind of active production immunity for the attorney, even though we don't have that type of immunity under our law.
Well, and I think the attorney could give it to a third party of his choosing under a modified order. Judge Locke's order here is obviously to maintain the device, but give it to a third-party custodian. The custodian drops it off, and the court drops it off in the Suffolk County District Attorney's office, and we'll never know how that chain of custody went, and certainly it doesn't matter. So we couldn't introduce it even if that was the way that it went. I do think that the search warrant...
And you would independently establish, that's what you would have to do? You would independently establish that whatever is on that phone is connected to this defendant?
Correct, based on perhaps contacts, mom, dad, brothers, sisters, work, so forth.
What if it wasn't a self-authenticating item like the cell phone? What if it was a silver medallion? How would you deal with that?
There you'd have a physical item of evidence that could be obtained with a search warrant. But I think to establish ownership, maybe video, maybe forensically, however the evidence played out.
You'd still have the identification problem that you would have with any item.
I think you would, and I do think in that case, if an attorney has maybe a bloody medallion, knowing that it's related to a crime, I think an attorney has an affirmative ethical obligation to turn that over.
After having a period of time within which to use it for purposes of consulting.
Yes, for example, if a client brought it to an attorney.
Right.
Yes, I would
brings
agree.
a bloody medal to the attorney may wish to have testing done on it and so on and so forth.
Yes.
Before there'd be any obligation, even on your theory, of turning it over.
I agree, yes.
So if you're right, you'd be proceeding by subpoena again and not by a search warrant. You'd be getting a subpoena from the attorney. I guess it's now in the hands of Mr. Rankin and Mr. Sultan of their law firm, and you then would be subpoenaing them under Rule 3.8 because
I think it would. I'm not sure that 3.8 provides the authority, as 3.8 is the ethical rule. I think it would fall more under Rule 17. But again, we're here to address not if the Commonwealth is entitled to this evidence. The question is, how does the Commonwealth get this evidence? And I think the concurring opinion...
But how matters a little bit, because if you're proceeding via subpoena, then you don't have the concern of the statute and the need to prove that this constitutes secretion.
And I think both apply. I think it's an either-or proposition. I think the Commonwealth could obtain the item via a search warrant under the framework that Justice Cordy sets out in the concurring opinion, or perhaps with a subpoena as the questions left open from the majority. And both of these turn on whether the period for providing legal advice has ended. So I would say the item is secreted for the purpose of 276(1), where it is held by an attorney, and it's no longer necessary for the provision of legal advice.
Is that settled issue? Is that settled that the attorneys no longer need it?
Judge Locke made a factual finding that 14 days was the period, and that 14 days has expired.
And counsel did not seek to get behind that ruling?
No, and it was an uncontested affidavit that set that forth. And again, here we're talking about the shell.
I mean, counsel doesn't think it should ever have to give it up, so I don't know that it would have taken on 14 days versus something else. I mean,
And was this on the basis of the sort of an ex parte sidebar?
This was not. The 14-day period was based on an uncontested affidavit by Sergeant Detective Kevin Witherspoon, who talks, it's in the record appendix, talks about how long it would take to download the contents of this device. Again, here we're simply talking about the device. Counsel only needs to possess the physical device for a limited period of time. What they do with what they obtain, the evidence, the documents, the data from that device is protected. The Commonwealth is not seeking that from the defense attorneys here.
Is it a crime to secrete evidence?
I think it is.
So is for an instant, as soon as the need for to examine the item for purposes of rendering legal advice, once that period of time ends, the lawyer, are you saying that the lawyer is potentially committing a crime?
I'd say potentially, but I would say most often not. I think certainly it's possible that the attorney can act with the nefarious intent, but it's not necessary.
So if the attorney does not have the nefarious intent, but is simply going to return the item to the client, why is that secreting?
It is holding it beyond the period necessary, and it might not be, again, with the intent to return it, that's fine. And I think in that instance, the Commonwealth would proffer the lawyer is holding this documentary evidence, this attorney no longer needs it, and then there's an opportunity to be heard. That the framework that Justice Cordy sets out provides for not an ex parte search warrant, but for the opportunity to be heard, and for the lawyer to say, yes, I'm done with it, I plan to return it to my client tomorrow.
So, and if the lawyer says that, and the lawyer has made an appointment to have somebody from the client's business come in to pick up the phone, could you get a search warrant to intercept it at that point?
I think you could, and I think
but it's not being secreted or secreted.
I think that it is, where it is being held, where it is no longer necessary. And maybe the argument there would be it's necessary because I intend to return it tomorrow. And it's a very specific factual determination. So, I mean, maybe that is part of it.
You need to define secrete as holding longer than necessary, right? I mean, that's basically, in your view, they mean the same thing.
Holding longer than necessary such that the attorney-client privilege no longer applies. I think that's where we circle back to Fisher. I think in both of these instances, you have the Fisher Doctrine applies and protects the item that was lawfully provided and provided for the purpose of legal advice, but where that continued retention is no longer protected.
But does a lawyer have a reasonable amount of time to retain the item for purposes of providing legal advice?
Yes.
Does the lawyer also have a reasonable amount of time to return the item to his client?
And again, I think that's a fact-specific determination.
The judge make a fact-specific determination on that point?
Not in this case, and I think this case might be a little different where the client is incarcerated. And here, at least, we did have a fact-specific determination of attorneys at Ropes and Gray no longer needed the phone, but Judge Locke did find, and this is based on the ex parte sidebars, that the phone was necessary to provide legal advice to the client in the hands of attorneys Rankin and Sultan. And so there was that interim transfer permitted, and the Commonwealth didn't contest that at the time, and although it doesn't have all the information, we don't contest that today.
Does that make the subpoena approach preferable to the search warrant approach?
I think that in the normal circumstances, the subpoena approach would be better because it is necessarily adversarial. It definitely provides notice to the attorneys. However, the framework set out in the concurring opinion is kind of a specialized search warrant approach that does provide that opportunity to be heard and the notice, which otherwise wouldn't be required for a search warrant. I think the standard for a search warrant may be a little higher with the probable cause showing than the Rule 17 subpoena.
Except if there is a question of privilege, in which case I don't know about how the standard would work. I mean, if something is privileged, it's privileged.
Absolutely, and there's no claim that the contents of this device are privileged.
No, I mean, even for the period of time that it's necessary to provide legal advice, they're privileged. They're untouchable.
Yes, it is.
Well, I'm sorry, before you go too far on that, we don't know whether or not, let's assume you get the cell phone. There could be communications, text between Mr. Hernandez and counsel, which would be privileged.
But counsel has not raised that.
Correct, and
Right,
the Commonwealth is not seeking.
And that will be pursuant to a second search warrant with regard to the search of the actual cell phone,
Correct. Where
which
there'll be-
hopefully will address the risk of attorney-client communications.
And will be specifically tailored for the probable cause to believe that there are communications between certain people on certain dates within certain date ranges, certain types of evidence, and this court has the framework in the preventative medicine
But
case.
let me ask you this, though. Assume hypothetically, because I know that it hasn't been raised here yet anyway, but let's assume that the phone contained lots of attorney-client communications. Would it be secreting if the attorney kept it because it's got something that is, it's not just for purposes of giving legal advice, it's actually protected, the
No.
substance of it?
I don't think that would be obtainable by a search warrant. To change the hypothetical, if the defendant wrote his attorney a letter and confessed to the crime, that is always going to be protected by the attorney-client privilege. That is a privileged communication, and that has no end.
So you would not get the phone in that instance?
We would not get those communications. Here, where you can separate that one page of the confession versus the phone, I do think that the Commonwealth is entitled to the device, and until the defendant makes that showing that it's otherwise protected.
But just to be clear, what you're asking for is a two-stepper. That is, the first step is either by subpoena or search warrant for you to get the phone, and then the second step would be a search warrant in order to search the contents of the phone. And during that second search warrant, you'd be addressing limitations on discovering attorney-client communications.
Yes, the first process is to seize the device. The second is then to search it, and while the defendant maintains a reasonable expectation of privacy in the device, it would protect his Fourth Amendment rights.
All right, thank you.
Thank you.
Mr. Sultan, good morning.
Mr. Chief Justice, and may it please the court. In January of 2015, this court held that the Commonwealth could not seek to obtain the target's cell phone by subpoena from his attorney based on a combination of the target's constitutional right against self-incrimination and the so-called Fisher rule, under which the law firm stands in the shoes of the client.
So do you read Fisher as really talking about the attorney, it's the act of production?
Correct. That's that under Fisher.
And in your view, that's never going to go away. That's always.
Well, that's correct, and I think and let me just say the court also added in that case that the Commonwealth could not seek to obtain the cell phone by search warrant either because of the prohibition on law office searches in 276-1.
But the search warrant does, assuming one comes within the framework of 276-1, the search warrant eliminates the act of production problem.
That's correct, Your Honor. If in, the statute, of course, provides that if court finds probable cause that the evidence will be destroyed, secreted, or lost, if a warrant does not issue, the warrant may issue. And
So let me ask you this question.
yes, Your Honor.
Is there any reason why your firm should retain custody of this cell phone other than to conceal its contents from the Commonwealth in the trial?
Absolutely, Your Honor. The reason is because this putative cell phone was turned over by a client to an attorney for purposes of rendering legal advice. That is undisputed in the case. And based on that, the act of production privilege, which is part of the self-incrimination, right against self-incrimination, basically moved from the client to the lawyer. So the lawyer is obligated to protect the client's constitutional right against self-incrimination under the attorney-client privilege.
The lawyer has no right to conceal evidence that's not privileged.
Well, Your Honor, the lawyer is not concealing anything.
Well, of course you are. Well, it depends on what you mean concealing. You're not letting it leave your office and not letting law enforcement that otherwise has a right to this to obtain it.
Well, Your Honor, to the extent that the evidence is unavailable to the Commonwealth because of a combination of constitutional privilege and attorney-client privilege, it is not being concealed. That is what the law requires. We are a government of laws. Their whole argument, Your Honor, rests on the idea that the attorney-client privilege has some kind of an expiration date. It doesn't have an expiration date.
But then the search warrant, are you saying well, I'll get to that in a second, but under the search warrant, what you say, the attorney-client privilege really goes to this standing in the shoes of the client for production,
That's
right?
on the subpoena side, Your Honor.
Yeah, but, okay. So in the search warrant, where's the attorney-client privilege?
On the search warrant side, there's no attorney-client privilege. On the search warrant side, there is a statute. And obviously, this court can construe the statute as it chooses to, but the statute says you can't get a warrant to search a psychotherapist, a clergyman, or a lawyer unless the evidence is going to be destroyed, secreted, or lost absent a warrant.
But doesn't the fact that the statute uses those three words mean that the legislature had in mind at some point the government was going to be able to use it? Because otherwise, why would you care?
Well, of course, Your Honor, the legislature had in mind that the statute meant something, but when the statute was enacted in 1986, that was 10 years after Fisher. So as this court said in January of 2015, the legislature presumably understood that there were some circumstances where a subpoena could not be used to get evidence because Fisher had been the law of the land for 10 years before the statute was enacted.
But do you see my point? I mean, why would the legislature care about secreting or concealing if it didn't think that at some point that evidence should be needed to be preserved in order to be available?
Well,
otherwise, whatever document the attorney had, he or she has.
Well, Your Honor, I think that really brings us to the rules of statutory construction. And I think you have to look at the words and what they mean. Secreted means concealed. Now, if Justice Cordy is correct, that conceal basically means they're not able to get it, then if that's the way this court defines secreted, then obviously they're going to fit within that exception in this circumstance. The fact is that in numerous other statutes, that's not what secreted means. Secreted means hidden, basically concealed, kept from view, basically hidden away. That is not the same as unavailable to the Commonwealth due to a combination of constitutional rights and common law privileges.
Well, let me ask you this. If you, put you aside, if an attorney has a cell phone under similar circumstances and decides it is going to bury it in some abandoned coal mine, you would say
secreting.
That's secreting, and you would say that the attorney may be involved in obstruction of justice by doing that. But the purpose of the attorney in doing that would be to make sure that what's on that cell phone never sees the light of day at trial. What's the difference between keeping it in your office and keeping it in that coal mine if it has the same result of keeping it from being used at trial?
The difference is that there is a statute which basically says you cannot get a warrant for a law firm or a therapist or a clergyman unless one of those exceptions applies. So even though the effect may be the same, which is they can't get it, but that does not mean that limited statutory exception has been satisfied. I mean, what's been going on in 2 years, Your Honor, in this, I think, in this matter, is that the Commonwealth feels there's got to be a way to do this. There has to be a way to get this evidence, surely. But the fact is, there is a combination of a constitutional privilege and a common law privilege which prevents a subpoena from issuing under a long line of cases like Commonwealth versus Hughes and the Fisher rule, and there's a statute that prevents a search warrant from issuing. So basically, the legislature can change the statute. If the legislature wants there to be a way for, after the so-called advice period is over, for the Commonwealth to be able to get evidence that has been turned over to a lawyer, fine, let them change the statute. But this court should not be essentially engrafting additional exceptions into the statute.
So it's your position that if this were the bloody weapon used in a crime and the client brought it to the attorney has no obligation under any set of circumstances or simply cannot turn that over?
Well, I think the bloody weapon is not documentary evidence.
Yeah, but under the Fifth Amendment,
Oh, I'm sorry.
I mean, I think the question is, because you're saying it's the act of production, so is it the same whether it's a I mean, put the statute aside. just as a Fifth Amendment matter, is that the production would be the same, whether it's a bloody knife or a document.
Well, I think that is a conundrum which, frankly, has not been clearly answered by this court in the Commonwealth of Massachusetts.
Well,
exactly
don't we need
what
to answer
what
this?
happens in those circumstances.
Don't we need to answer something like that here?
I'm sorry, Your Honor?
Don't we need to answer something like that here?
Well, I think that it would be.
Neither is subject to privilege.
Well, I think it would be helpful to give everybody guidance on that subject because, frankly, there is no guidance. Under Hughes, as I read Hughes, I think it would be problematic, frankly, if I mean, this is the case that every lawyer fears, that the client brings in the weapon and says, here, you hold on to this. This court has said in Hughes it could not be obtained from the client by subpoena. If under Fisher the lawyer stands in the client's shoes, I think it's a conundrum for lawyers. And I would, as one lawyer, I would welcome this court in shedding light on my obligations and my colleagues' obligations in those circumstances. But that's not this case.
But has any court shed any light on this? I mean, do we have guidance from any other
There are
court?
courts all over the country, Your Honor. There's a lot of old cases that's taking different positions about, some say a lawyer has a sua sponte obligation to call the prosecutor up and hand it over. There's other courts that say...
There's actually a lot of cases about weapons. And, I mean,
Well,
items.
yeah, that's sort of the easiest case. But
computers can now be weapons.
well,
as it
here we're
turns
talking
out.
about documentary evidence.
Well, we're
and-
talking also about electronic evidence,
Yes,
which
Your
is your argument that a cell phone is included within the definition of documentary evidence.
That's what this court has found in its
So we're
prior
talking
decision.
about get your computer to your lawyer fast if you've been committing crimes on it.
Well, I think that it is a subject that requires elucidation in general, apart from this particular case. As a member of the bar for a long time, I've never felt I had guidance, either in the disciplinary rules or in the common law of this court, that made it clear to me where those lines are drawn and where a lawyer's obligations lie. In this case, I think it's where you are talking about documentary evidence. I think the Fisher rule clearly applies. The act of production privilege applies. There's no time limit on those things. And similarly, on the search warrant side, I just don't think secreted. I think it's twisting that language to turn it into the lawyer no longer needs it, therefore it is secreted, or it's unavailable to the Commonwealth, therefore it is secreted. That is not what the term secreted means under numerous statutes, under numerous cases that this court has decided, and to sort of twist the meaning of that term in order to provide the Commonwealth with an avenue to get through this thicket to where it wants to get, I think is an inappropriate use of really what amounts to judicial legislation. I think it's up to the legislature if it wants to create some further exception in 276(1. The legislature can do that, but under the language of the statute, I think the language is clear, and it's not being secreted. It is simply, if it's being held, it's being held pursuant to a constitutional right of our client and a constitution and a common law privilege, which has no time limit. The attorney-client privilege never expires.
Yeah, but
See, then let's go back to the Fisher issue, because it seems to me that the Fisher issue presumes that the lawyer holds it for the purpose of rendering legal advice.
No, it presumes that it was given to the lawyer for the purpose of rendering legal advice.
Oh, and that one act of just giving defines it forever. It doesn't.
Well, I think it does, and this court, frankly, in its prior decision, I think answered that question because it said that the policy behind Fisher is that we want to encourage clients to give stuff to their lawyers for purposes of rendering legal advice, and if the client is going to be put in a worse position, then the client's going to be reluctant to turn it over. So yes, if that's the law. Once it's handed over for that purpose, it now fits within the Fisher rule. And I haven't found a single case that says time's up, expires, attorney-client privilege no longer applies.
Hey, that's why you say the Commonwealth's idea of giving even to a third party doesn't solve that problem, because if the underlying purpose is to protect the client in giving his or her attorney everything, that's not going to do it.
Exactly. We're not trying to find a way to kind of get around this problem to basically so that the client is put in a worse position. Once it's handed over for that purpose, it's privileged. And in the ordinary course, they could get it by search warrant, but there's a statute that says they can't. That's where we are.
So let's play out whether the client is worse off. Okay, the client could have held on to the cell phone and be subject not to a subpoena but to a search warrant.
Correct.
By giving it to the attorney, the client is protected from a search warrant unless the attorney is going to be secreting it. And again, no one questions your good faith or Mr. Rankin's good faith during this matter. This is a constitutional question, not a matter of your intent. But at some point, once you say, thank you, I've looked at it, you could, in theory, return it to Mr. Hernandez, and then he could once again be subject to a search warrant. Of course, you'd have to be giving it to the prison authorities to give to him, and they would probably hold it.
Practical problem.
So there is a practical problem. But are you, are you putting a client, I guess, in a better position by giving it to his attorney than it would be if he held on to it? That's part of the concern. I mean, you clearly don't want the strategy of every criminal to be, as soon as you hear that you're under investigation, hand the computer over to your attorney, and that will protect it forever.
I understand. And it may well be that in this particular circumstance, it turns out he is in a better position, just by dint of the things that have happened. But I understand the court's concern. And again, I think that it would be extremely helpful if the court would spell out to all of us in the bar what the rules are in these circumstances.
Can I just ask you a question about that? If we assume that the client isn't in prison, and so, actually, I think Mr. Katz indicated this in some affidavit, that, in normal circumstances, when the cell phone had been had been examined, the law firm would have returned it to the client.
Correct.
So what's the difference between that and in this circumstance, since you really can't give it to the prison, giving it to a third party?
Well, because the act of production, if the act of production privilege belongs to the client, it goes to the attorney. It then would not go to the third party.
So you could give it to a third party and get a search warrant on the third party.
Correct. Yeah. So there's a way that would again give them another avenue. And I'm not saying they shouldn't have an avenue. I'm just saying that under the current state of the law, I don't believe they do.
All right, thank you.
Thank you, counsel.